All right, welcome back. We are here at General on Housing to go through several more bill introductions. And so it's not just all me all the time this morning. We have asked Representative Michelle Boslin to come in to introduce H-135, which is an act relating to capping annual rent increases and security deposits. Do you know everybody here? Can you honestly say you know everybody here? Shall we go around?
I don't know people that are sitting beyond the inner circle. At least I don't know this.
Oh, you can just imagine that you're nearsighted and you can't really see.
Okay, all right.
That's fine. So welcome. The microphone is yours.
Okay, my name is Michelle Boslin. I'm a representative from the Wyndham 3 district in northern Wyndham County. I've been in office only for one term. I'm starting my second term. And I'm going to give a little bit of background to why I ended up introducing this bill. And it has to do actually with the town that I represented in my old district, which was Wyndham 4. So I was a representative for Putney, Dummerston, and Westminster. And I have a constituent who lived in Putney in a small 2-bedroom house. And the first year she was there, her rent was $1,250. And then a year later, her landlord said, to stay here, we're going to reevaluate your lease and it's going to be $1,500 a month. So she thought that was a little bit of a big rent jump, but she liked the place and she wanted to stay. So she continued in the apartment and paid an extra $250 a month for the next year. Well, then you fast forward to this last summer and it was time to renew her lease again. And her landlord said, it's going to be $3,000 for you to stay in this house monthly for the next year. And she said, the rent's going to double. And they said, yes. And she said, I can't afford that. And so she moved out. So she no longer was in my district and she no longer was in that town. And I've heard, since I heard about her situation, my son actually was helping this woman move. And he came back and he was all riled up and he's like, Mom, what's going on? What's going on in Vermont that we can't have people stay in the homes that they're living in because their rents are being raised so exorbitantly? And I said, I don't know, but it's a problem. And he said, well, the lady I just helped move told me that some states have laws that prevent this kind of thing. Why don't you do something about this? And I thought, wow, all right, he's my constituent too. And so is she, or at least she was. And I'm like, all right, I'll look into that. And it turns out there are a number of states that have introduced this kind of legislation. Depending on the state, sometimes they call it rental caps, which limits the annual amount of raise of a rent from one year to the next. Sometimes they call it anti-gouging bills, because basically if you're changing someone's rent from one level to double or more than double, that really is gouging. I mean, I think it's fair for anybody who's a landlord to make a profit on their investment. Like, we absolutely need that. We need landlords to have properties available for Vermonters and for people from out of state to come and visit us. But we really need to have a stable housing situation where a person who signs an agreement about their rent is not going to be surprised that they're going to have to move a year later by an exorbitant raise. That's not appropriate, and it's not what we want for Vermonters. So what's the bill? The bill has only two parts. It's a very simple bill. It's a short form bill. The initial section of the bill addresses the rental cap portion. So it caps the annual amount of raise for a rent from one year to the next at no more than 6% annually, or the average of the previous 12 months consumer price index. So for example, last year, the average consumer price index for the US was 6.5%. So if this law were in place, 6.5 would actually be the cap for this next year, not 6%. So it does take into account if there's an extraordinarily high rate of inflation, that does account for that. There also is a section in the bill that says that there are certain circumstances where the rent could be raised beyond that if there were particular improvements made on the property. So for example, if you had an apartment and it didn't have central air conditioning and that was installed, that might be justification for a slightly higher raise. But in general, the majority of cases, it would cap no more than 6% for most renters. And even that would be a stretch for some people, but it certainly would be more affordable and I think would keep people in their homes. The other aspect of the bill has to do with security deposits. I've actually heard of situations where landlords are requiring first, last, and security, which basically means you need to pay 3 months upfront. And a lot of people can't afford that. So Elizabeth Burrows is my co-sponsor, so correct me if I don't get this part correct. But I believe what our bill has suggested is that the security deposit would be 1 month, 1 month's rent. And you can apply that to your final month's rent if they do an evaluation prior to your moving out and everything is acceptable in the last 30 days. Is that right?
Yep.
Okay, so that's it. Does anyone have questions? Or thoughts?
I don't see it on here, but a lot of places don't get reappraised for quite a while. For reappraisal, jacked up the landlord's taxes. Would you see that as a reason for a higher number?
I mean, I would suppose that could fall into the category of if the expenses were, if there was justified expense raise for the landlord. I don't know for sure. I mean, in the end, your committee is going to be the ones who are going to determine those kind of details.
Yep.
But my guess is that could factor in.
I guess secondly, and probably pretty much the exact same answer. If the landlord hadn't raised rent in 5 years, you don't see them as being able to take that past 5 years.
That would not be my understanding of how it's worked in other states.
Okay.
Yeah. The idea is to make sustainable raises in the future, not to play catch up for what, did or didn't happen in the past.
Yes, Representative Bartley.
I have a question regarding the security deposit. So I'm reading it right now, and it says, which may be applied at the final month's rent if no damage is discovered at an inspection that occurs not more than 1 month prior. Never mind.
Make sense?
I reread it yet.
Okay.
Representative Howard.
Thank you. Do you know what states have this law?
There are different variations of it. Some of the language from this one actually came from a bill in New Jersey. I did also look at some bills in California and Oregon. But the language from this one was the closest to what Representative Burrows and I had in mind. So we went with that model.
Thank you.
All right, any other questions? No, thank you for bringing this forward. It is definitely part of the housing crisis that we talk about. And so if we consider this, if we consider this through this bill, because I believe there's language that's similar to this that appears elsewhere in our world. But if we consider this bill, we have to vote it off the wall, the short form routine. And then we'll ask you who the best, if there's individuals that you want us to hear from.
Okay. Okay. And I have spoke to people from different housing organizations, and many of them have concurred that this would be something that would be very beneficial, particularly to low and moderate income Vermonters. So.
Yes.
Also, I just want to add in about part of the discussion that we had about what rate to set it at. And the lady who I'm staying with here in Montpelier is a renter. And so I talked with her about what rate we should set it at. And I said, we were thinking about 10%. And she said, well, you take $1,000 rental, and if you're allowed 10% increase, then, that's what landlords will go to. And so 10% 1 year is $1,100, and then it's compounded year over year. So that means it's within 5 years, it becomes really exorbitant.
Sure.
So that's why we landed a little bit lower.
Sure. Yes.
Sorry, I just thought of another question. So some landlords provide utilities for their tenants. Say hypothetically, a landlord decides to no longer provide that. Would that increase, because obviously the tenant would have to then pay.
Yeah.
Would that be included in that 6%? Would that, I mean, it's technically different, but obviously it's
My thought is that if you change the status of the rental agreement so that what had been covered was no longer covered, that would need to be factored in terms of determining what was happening for the future. And honestly, like that isn't accounted for in the short form bill, but when you get to a fuller fleshed out version, I would think that would be something important to include, because that would dramatically change someone's expenses if they took away some of the things that had been included.
Yeah, absolutely. Thank you.
Thank you so much.
All right, thank you.
Thank you. I'm cutting off that rabbit hole, just. No,
Sorry.
it's good to state it, but it's.
Thank you for reviewing.
Thank you so much.
Okay, yeah, bye-bye.
I'm back up. All right, so you have to check, you have to be in charge.
Okay.
Let's see. I did want to, can you, from our page, can you bring up actually H-132 under my name?
137?
I'm gonna do, 132 and 137, and I don't think I'll have enough time to do the mobile home park one, but I wanted to do H-132.
You refresh your screen, so it'll be done.
Gotcha, thank you.
Oh, Robin, you're in charge, I'm sorry.
Yes. So, welcome. I don't believe that you need an introduction around the table.
No, everybody's familiar. Actually, it looks like I'm looking at the Zoom screen.
So starting with 132, H132, please tell us what the bill does.
Great, thank you. This is yet another bill. Sometimes when I sponsor bills as a chair, sometimes it's just trying to get bills that
I'm
have.
sorry, for the record.
For the record, Representative Tom Stevens from Waterbury.
Thank you.
A lot of times when I try to get bills like this out, it's because they've been on the wall for some bienniums past, and I just want to make sure that they get considered again. This bill originally was introduced by now Senator Ron Hinsdale probably 10 years ago. And it is considered the homeless, it was originally produced as the Homeless Bill of Rights, and it still says this bill proposes to establish a Homeless Bill of Rights and prohibit discrimination against persons without homes. And so it goes through several sections, and then that would create some form of Bill of Rights, and then it'll also add language to our discrimination statutes that would add someone's homelessness being part of a protected class so that they couldn't be discriminated against simply because they're experiencing homelessness. I wanted to introduce this today because it is part of what I would like to consider over the course of this year. And it's been bipartisan or tripartisan sponsorship. To me, it's worth going through and understanding what it is. In years past, we had a different attorney on this who viewed elements of this bill to be unconstitutional, but they were addressed, but we never went further when the pandemic came. While it makes sense to have had a Bill of Rights when we were trying to protect people experiencing homelessness, it just wasn't going to happen during the pandemic, and we kind of got stopped from moving the bill forward. And so it's now 4 years later, and just like to go through it again and see if it's worth considering at a larger level to see if we've handled some of these items just by the experiences that we've had, or if we need to incorporate them into statute. So that's the basic introduction. I won't do a walkthrough now. We can do a walkthrough at a different time.
An overview of can you just a quick.
Yes,
Down at the-
so I'm sorry, what is the Bill of Rights? And so in section 2, actually, if we go to if you just simply go to the findings, which is on page 1 and 2, there's statements that at the present time, many individuals have been rendered homeless as a result of economic hardship and a shortage of safe and affordable housing. Our constitution says that Vermonters should be equally free and independent. As a result, an individual should not be subject to discrimination based on their individual's housing status or being homeless. And it's the intent of this act to help mitigate both the discrimination individuals without homes or perceived to be without homes face and the adverse effects individuals and communities suffer when an individual. So that's your statement of purpose, basically. So basically, under section 2, it's a right to move freely in public spaces. So the definition of what a public space is very important. It's equal treatment by state and municipal agencies based on their housing status. Many people who are experiencing homelessness because they can't provide an address, for instance, people will not hire them. We had Chris Delia come in from the Bankers Association talking about why it was important to change this proposal so that to accommodate federal law that people who have certain accounts have to have addresses. It's an expectation of privacy in the individual's personal property. This was without discrimination based on an individual's housing status. This came to the forefront. The language existed beforehand, but it came to the forefront several years ago when the police raided a homeless camp in Burlington and damaged or destroyed lots of personal property. The controversial piece, at least when we took testimony on it, was section B, notwithstanding any provision of law of a municipal charter or of a municipal charter that no individual shall be subject to civil or criminal sanctions for soliciting, sharing, accepting or offering food or drink. There's been some proposed ordinances in cities and towns that have said that you can't give money to people that it's illegal to give money to people or to accept it. And into the discrimination part, no law, rule, or ordinance shall adversely impact or penalize an individual based on their housing status. So when we do discrimination law, we can still conceivably discriminate. Like, it's still legal to discriminate against people, but when there's a protected class, this is saying that I'm not going to provide you a house because you're currently homeless. Homelessness may be one of the reasons why it's difficult for people to rent, because they may not have a job, they may not have the stability to rent. But if someone says that I'm not renting to you because you're currently status and I can't find anything else about you, that's discriminatory. I mean, I could say your job history, you're not proving in the way that we ask you to prove in some way. That's not based on their particular personal standing as individuals. Yeah.
The question, Representative Burrows.
Thank you. Has there been any discussion about the actual practicality of a person with unstable housing bringing a lawsuit regarding discrimination?
Not that we're aware of, or we weren't aware of several years ago, though there have been the cases in Burlington that have, some of the cases have, on a legal basis, have been ruled against the plaintiffs, but nothing specifically where I take you to court and say you discriminated against me because I was homeless. So there, to my knowledge, there hasn't been anything in Vermont, but that's something we could look into.
Representative Stevens, one of the first things that you mentioned was freedom of movement. And I know there's been, I don't know if there have been legal cases, but there's certainly it keeps coming up. Owners of convenience stores or supermarkets say, we don't want people hanging out in front of the door all day, or groups of people. This would seem to prohibit their ability to do anything about that situation. Is that?
If they're, on the face of it, if they're asking everybody to move off of their sidewalk, then they're not discriminating against any individual person. If they're merely picking out people who are perceived to be homeless, then, or could be experiencing homelessness, then that might be considered discrimination under this. And the idea here of public places, including public sidewalks, in section 3, we'll get to the more straightforward language without making, this section 2 is basically the Bill of Rights, which are statements and regulations about how a person experiencing homelessness or a household experiencing homelessness should not be treated. But going into section 4, where it's just adding.
We had questions also from Representative Bartley and Krasnow. And Ben, we'll let you run through the rest of it.
Sorry, I'm not really used to this.
We've got to keep you in check.
Thank you. One question that came up for me, as someone with a past in human resources, when I hire anybody, I have to get an I-9, which is federally mandated, and you have to put an address on there. How would that play into the federal mandate of an I-9? Do we have any idea of how to implement that regarding this? Because right now I can't hire somebody or I can't have somebody work without an I-9.
Right. That's a good question. And I'm not sure where in the exemptions, or where we have the status, how that fits. And that's something that we can certainly discuss, though that seems to fit with what Chris Delia was saying, was that for certain federal purposes, you need to have a standing address.
Mhm.
So, question to Tim.
Yeah, I guess this could go into the same, I was curious if voting was involved in any of this as well.
Again, how do people do it now? Or, if they're on the voter checklist, I'm assuming that when they go to vote, that there's not a question of whether they're currently homeless or not. So maybe a question of registering to vote.
Right.
And that may not be covered.
And then the other thing I was curious about, so in South Burlington, we have an ordinance for camping and tents popping up in the city. And one of the things that I fought hard for was to make sure that folks had a place that the city would store their belongings for up to 30 days, which matched other municipalities. And I was just curious because you had mentioned about people's belongings, and maybe we'll get to that, but is that the responsibility of the state or municipality to do something with the belongings, or are they just not destroying them?
Again, it's a gray area to the best of my knowledge, where when it comes to rental law, there are numbers, there are days, business days, there's certain things that people have to do if they're dispossessing or they're trying to repossess the apartment. I think the question that comes up is when you are at a campsite and you're carrying your belongings with you, you're not renting, so I think that this is trying to say that you can't come in and treat them in a way that you wouldn't treat anybody else. There may be statutes that allow it technically, but this is trying to say that that acknowledges that you're experiencing homelessness.
That's great. Yeah, no, I think that's a really important piece of this. Thank you.
Representative Labor.
Thank you, Robin. Not all people are homeless because of economic status. Some are homeless because of choice. In my campaigning, I came across an individual that surprised me a little. She was living in a tent on private land, 25 feet off the highway. She was bathing in the fishing access. Her clothes were spread out on the guardrails to dry out because it had rained that night. She had no cooking utensils. A neighbor provided her with vegetables that didn't need to be cooked. And another neighbor supplied her with firewood so that she could have heat, at least on the cement portion of the fishing access. So my wife and I stopped and we observed her. And I said, something's not quite right here. Interviewed some of those neighbors and found out those details. So then I went to Human Services to see if I couldn't help her. And is there a child involved? No, there was no child involved. There were no toys, single person. Well, we don't do that unless we have a child involved. You need to go to NECA. Okay, so I went to Northeast Kingdom Community Action. Why, yes, we would be glad to help her. Okay. So that was a Friday. Saturday morning, the supervisor from NECA and an employee went out to interview her. Not only was she very happy where she was, she refused a motel room and refused to get in the car to be transferred to a motel that was close by, or even down to St. Johnsbury. Well, because of HIPAA, only certain information can be relayed back to me.
Right.
And I found it disturbing when it got down to 28 degrees, that a person would be living in a tent without heat and no other visible means of support. It was her choice.
Yeah.
How do you handle something like that?
In this or in
It's
just
well,
life in
particularly,
general, you know, and
How can this bill be rearranged or rewritten to make it more passable?
well, I think that's our work, if we take this up, to be quite honest. I mean, you know, in terms of the individual that you're talking about, this goes into a similar vein as involuntary medication, right? We're not supposed to medicate somebody involuntarily for mental health issues or other physical issues. It's a consent issue. And I think that's what we're talking about here. I think we offer the tools when there's a cold weather exemption, when the weather goes below 20 degrees and shelters are opened and people are allowed to get vouchers with minimal requirements. Of course, during the pandemic, anybody who needed a place to stay received a place to stay. And they weren't permanent, but in essence, during the pandemic, they were, but it's a consent issue. I think when people show up at a site like that, they strongly advise somebody to come inside. But if they insist on staying outside, then, or that they'll be fine, then I think that's a very difficult line for us to cross.
Well, I did go to the sheriff to see if they had her on their radar screen. And they said, we are aware of her, period. But because of privacy laws, they're not going to discuss any further.
Yeah.
A week later, she was not there. So I did what I could, but I was frustrated by the part that you can't move a person who's voluntary to do that.
No, and you know, we've learned over the years that these are rough numbers, but 35% of the people who experience homelessness, it's a I just lost my job. I was one paycheck away from losing my stuff, and they may need financial help to get back on their feet. Perhaps another 35% are harder to house, whether it's mental health issues, whether it's chronic joblessness, disability, and they require more services and financial help. And then there's about 30% of the folks that are very difficult to keep housed, and probably a smaller percentage of that they feel like they're choosing to be outside. We've heard about this from veterans, we've heard about this from other folks who want to live outside the system, who don't trust the government, they don't trust any of the services that might be available to them. They also must be, there was an anecdote about an individual when South Burlington opened the Beacon Apartments, which were for chronically homeless disabled folks, of which they encountered there was 65 or 66 in the Chittenden County area, and they were able to house almost half of them in this renovated motel with investment by the medical center, because the theory being emergency room beds are the most expensive hotel beds in the state. And they had an individual who the first month he lived in the place, he kept his tent up. And it took him a month to just realize that he has 4 walls and a door to close in. But just that sensibility that they were carrying with them just was really, those are the reality things that step outside what we deal with in this building directly. So
what I'd like to do is give Representative time to get through the rest of the bill and then ask questions at the end, unless it's specifically.
Yeah, it wasn't a question. It was just a statement, just a more that I think what this does is, even whether you choose, regardless of how you became homeless, it's just to give you the right to be treated like a human with dignity and respect. Is that an accurate statement?
Yeah.
That was the only thing.
And that comes under, so section 4, thank you, I won't get to the other bills, so that's fine. So section 4 is the conversation about public accommodations was a lengthy conversation, because a public accommodation is essentially any place where the public is or can't be allowed. And so this is simply saying that, and if you have a public accommodation, that you can't prevent someone solely because of their homelessness, their housing status, that they aren't allowed in. Section 5, and this is all relatively standard protected class language that exists in different sections of law. So section 5 is about unfair housing practices. It's adding one's housing status to the list of protected classes, which is race, sex, sexual orientation, gender identity, age, marital status, religious creed, color, national origin, or disability of a person. Or because a person intends to occupy a dwelling with one or more minor children, or because a person is a recipient of public assistance, or because a person is a victim of abuse, sexual assault, or stalking. So we have more protected classes than the federal protected classes. So that's section 5, just adds housing status to those different different discrimination sections. Just top of page 7, to engage in block busting practices. Mr. Chair, do you know what block busting is from a realtor's perspective?
Yes.
So please share.
A number of practices, blockbusting, redlining, are basically prohibiting people from not overtly prohibiting, but as a realtor, you cannot steer people away from a particular neighborhood because of, or into a particular neighborhood because of a protected class like race, ethnicity, religion. In fact, as realtors, if somebody says, I'm actually looking for a home close to the Catholic Church, we can't just show them homes near the Catholic Church. We can show them homes near places of worship. We cannot narrow our search to include only Catholic churches. Is that the?
And block busting is that's red line. Block busting is when people choose to actually let their block
Oh, yes.
go down in quality or oversell to people that they don't want in the neighborhood so that the rest of the people move out. And they make it not nice place to live. So this section is all about housing. Block busting stands out because it's a phrase that probably was incorporated into the language 50 years ago or more. And that this section about housing goes on for till page 8. Bottom of page 8, we get to definitions, which defines what housing status is. Section 7 is about discrimination in employment practices. So that would be something that we would review. And it goes through a bunch of different employment ideas. And then section 9 states that gives a definition of housing status to the section on benefits. So it's I have to review with the attorney. I would have to review. I believe Damien has this bill now, and he was left with notes on what we were trying to do before might have been considered unconstitutional. And so if we get to it, I'd like to be able to get to it this biennium. And given that how much we're dealing with homelessness and how many people are experiencing it right now that we know of, it may be something that works for them.
Representative Burrows.
If we get to this bill, this biennium, I would request that we rethink the terminology involved.
Sure.
Other comments or questions? If not, thank you.
Thank you.
And we will see you all back here at 1:15 according to the schedule.
Thank you.